Hey everybody, Future Patrick here. This is the second half of a live stream that happened yesterday. Uh, I probably should have invited Stephan back for a separate stream on this topic because it's really cool, but it definitely deserves its own video. So I'm editing it out of the full stream and releasing it as a focused video on the topic. So hope you guys enjoy.
I thought this was a cool topic. Would you like me to read it, and then maybe we can talk through how it came to be and why, and the challenges behind formulating language like this? Or do you want to read it?
I would read the whole post. Let me just explain what happened, and maybe you can interject when you need to clarify something.
Cool.
So basically, I was at the Reno Libertarian Party convention in May when the Mises Caucus took over, and also got some changes made to the platform. And I was involved with that, and I was asked to help clarify or to write a plank on aggression and property rights, which did not exist in there. It was sort of like implied, like aggression was mentioned a couple times, but it was never defined. Property rights were never clearly defined. So I wrote one, and it was put in there. It's in 2.1, and I wrote it in a particular way, with input from some other people on the Mises Caucus and some feedback, and went through several iterations. And if you want to read the actual language, you can read the language of 2.1. It's two fairly short paragraphs. You want to do that?
Yeah, and I think it's cool to do this because everybody thinks it's really easy to define the terms that we use when we're talking about liberty until you say, okay, go do it. And then you find it's actually really complicated to make this lossy thought compression algorithm that is language spit out consistent principles. And I think he did a pretty good job here in codifying. 2.1 defines aggression, property, and contract. Aggression is the use, trespass against, or invasion of the borders of another person's owned resource, property, without the owner's consent, or the threat thereof. We oppose all acts of aggression as illegitimate and unjust, whether committed by private actors or the state. Each person is the presumptive owner of his or her body, self-ownership, which right may be forfeited only as a consequence of committing an act of aggression. Property rights in external, scarce resources are determined in accordance with the principles of original appropriation or homesteading, whereby a person becomes an owner of an unowned resource by first use and transformation. Contract, whereby the owner consensually transfers ownership to another person, and rectification, which I think is the same thing as tort, right? I had never heard.
No, it's the same thing as restitution.
Oh, okay. Whereby an owner's property rights in certain resources are transferred to a victim of the owner's tort, trespass, or aggression to compensate the victim. Do you want to read the third paragraph?
No, the third was already there. I just added these ahead of that, so that the third just goes into some specific examples. But so most libertarians would say aggression is the initiation of force, right? Something like that. But that's not really a good definition because it's kind of awkward. First of all, that doesn't include threats, and it doesn't include fraud, at least on first glance. And it doesn't, like if I walk across someone's lawn at midnight when they're sleeping, did I really initiate force? It's kind of odd. I think the best way to understand it is this. And the way I worded it like this was for these reasons. The word aggression, like on its plain meaning, means like when you physically hit another person, like they're physically fighting, right? And if you say you're opposed to aggression, what you mean is you're opposed to like hitting other people. Mm-hmm. And that's just another way of saying each person owns their body, right? Because if it's impermissible for me to hit your body, that means that you're not consenting to it. And the only reason I need your consent is if you own your body. So it's another way of saying self-ownership or body rights. So that's why I put that in there first. So every person owns their body, but that right is not unlimited for the very reason that you can't use it to commit aggression. In other words, someone can't initiate force or aggress against me, but they can use force against me to repel me if I'm attacking them. So when I commit aggression, then I am forfeiting some of my rights in my body. I'm effectively giving you permission to hit my body back. Okay, so that's why I put that exception in there. But basically, self-ownership is the first property right. So aggression is the use of someone's property without their consent, and the property would be their body. And then the other things that we consider property are external resources that were at one time unowned, that came to be owned, and that are owned by someone now. So all legal disputes have to do with two or more people contesting the ownership, the right to control or use a given scarce resource, an external resource. And the way that we determine the owner is with homesteading, like who got it first, contract, like did you get it from a previous owner by contract, or was it transferred to you because someone hurt you, like they committed a tort against you? So that'd be rectification. So those three things, those three rules are the only ways that you can come to own property. You either the first one to get it, or you buy it from someone who had it, or they have to give it to you to pay you back for some damage they did to you. That's the only way to get ownership of something. And this way of putting it has several implications. Number one, it implies anarchy because the state violates these rules when it taxes us or outlaws competition, right, by monopolizing its services. It also implies intellectual property is not legitimate because intellectual property doesn't come about through any of these things here. In other words, intellectual property gives the owner of the copyright or the patent the right to stop you from using your property as you see fit, which violates your property rights. It also rules out voluntary slavery because the contract part only applies to external resources, not to your body. Your body, you can only lose rights in your body when you commit aggression. So that compact way of putting it has several implications, but I think it covers the whole field. And one thing we didn't list explicitly, I did list threats because the threat of force also counts as initiation of force or aggression, because it gives the person receiving the threat the right to respond, right? So if someone has a right to respond, then what they're responding to has to be aggression. But I didn't call out fraud specifically because fraud is implied. That is a prohibition against fraud, because the word consent is in there. The use of someone's resource that they own has to be with their consent. And fraud is a way of vitiating consent. You're deceiving someone about the nature of what's going on, and the consent that they give is not really informed consent or meaningful consent. So fraud is an application of that too.
The only I was about to say the only nitpick I have, but not even that. It's mainly a question because you were the one that convinced me of first use as the only necessary homesteading action. Like, get there first and make first use of it. In here you say first use and transformation. So I just wanted to check and see if you meant something additional with the word transformation, or if that's kind of superfluous. Like, what if you just got there and used it first but didn't transform it in some way?
The transform sort of implies that you have to use it in a way that establishes some kind of publicly visible link between you and the resource. So that other people can see that there's property borders or property boundaries. There has to be a visible, Hoppe calls it intersubjectively ascertainable. We can just call it objective. There has to be an objective, provable link between you and the resource. So there has to be some stamp of your connection to it. If you just walk across it and leave, then no one even knows you were there. And if you claim it later, it's like a mere verbal declaration. So transform just means doing something with it that separates it out from other things, so people can tell that now this is owned. It basically means putting up a fence around it. It means establishing your ownership in a visible way. Transforming is one way of doing that. Go ahead. Sorry.
I was just going to say that I think the word transformation bothers me because it summons back in the mix that whole mix your labor with it, labor of theory of value. Your labor has something magical. You doing something to the property makes a difference. Whereas, the example I use when I'm talking about it is like a worm farm. You homestead a piece of property, or you wish to homestead a piece of property that has a bunch of worms underground. And if you disturb the ground in any way, if you modify or transform the property in any way, you might make the property less efficacious as a worm farm. So really, you're just going to say, hey, this is my property. I got here first and I'm using it as a worm farm. And then,
correct.
I guess if somebody challenged you, go ahead.
I would say but you need to somehow establish a publicly visible connection between you and the worm farm. Like maybe you'll put a fence around it, or something. You have to do something. The word transform is, I think of it as a if I was writing a treatise, I would give different examples and have footnotes and nuances. But the problem with the mixing your labor thing, I think Locke is in a way right, that when you mix your labor with an unknown resource, and all he meant by that was you transform it or you do something with it. you start using it basically in a certain way. The problem with his argument is that he assumes that the reason it works is because you own your labor. So it's kind of a mystical argument. And it leads to the IP idea, actually. You don't need to say you own your labor in order to say that mixing your labor with something is one way of homesteading it. In other words, mixing your labor with something is a way of embordering it. I mean, the general concept is what Hoppe writes about. It's called embordering. It's basically establishing a publicly visible link between yourself and the resource. And that depends upon the nature of the resource, too. You know, cows are homesteaded by branding them because they roam around. Land is transformed in a certain way. Other things are homesteaded by possession, you know, like a stick or something like that.
So this is interesting. I've gone for years now without saying that you needed to separate it from nature. And I guess this is not the same thing you're talking about. Embordering, I think, is the perfect word, actually, to establish borders. Emborder, I like that. I'm gonna have to continue thinking about that. And I'd like to get your answer on the most common criticism I get when I talk about first use as the prime homesteading rule is what constitutes use? Because, you know, you could sit on the top of a hill in a lawn chair and be like, oh, I'm using all of this land with my eyes to enjoy the view, for example. Therefore, I have made first use of all of these vast tracts of land. Therefore, I have now homesteaded it all. What do you say to that? Yeah,
that's I think this is not like an a priori thing you can come up with from your armchair. This has to come from the kind of negotiation between people in reality. But you have to remember that anytime there's a dispute over a resource, then that dispute is over a particular type of use of the resource. So two people when they have a conflict over a resource, it's going to be a conflict over a certain type of use, and that's going to depend upon the way the people want to use it and the nature of the resource itself. So the very nature of any dispute, like when two people come into court to argue who gets the thing, the very thing that they're fighting about helps to define the type of use appropriate for that thing that then would be the standard for who homesteaded or how was it homesteaded. So it's sort of a, now in particular cases you can give an answer, but I think that as a practical matter, yeah, you can't just observe something and claim it. You have to actually somehow emborder it. Now, let's say you put up a fence across, 1,000 square miles. You could claim that you've embordered it, but if you're not actually using the whole thing productively, then you're not going to be able to make enough income from that property to have resources to go around policing it all the time. So eventually people are going to start squatting on it, and they're going to gain ownership of it by acquisitive prescription or statute of limitations, which is another way of saying that I've effectively abandoned it. Like if someone squats on a corner of my property 100 miles away and I never tell them anything, and 100 years later they have a thriving town there, I've given up ownership of it. So unless I'm actually using this thing productively, it's impossible to homestead too much, because you're going to lose ownership of it at a certain time to squatters, basically.
There's so many different things happening here. So what was the thing you said right before abandonment? It was two words I'd never heard. You said if somebody is squatting on the land.
Acquisitive prescription.
Acquisitive prescription. Can you tell me what that means?
That's a civil law term. It's usually called statute of limitations in the common law. Acquisitive means to acquire. Prescription means the time limit has run out.
Okay. Now I have previously held up until this moment, and I guess I'll defend that position, that there is no such thing as sort of like abandonment as long as the owner is alive, unless they take positive action to abandon something, like this sort of nascent or late, what's the word I'm looking for? This sort of like abandonment by default. I don't think it's a subjective thing that you can't really prove. Like if I have a watch and I put it down and I walk away, that's in no way really communicating definitely that I've abandoned that piece of property. I could have just wanted to leave it there and walk away for a month. What do you say about this abandonment stuff? Because it's a tricky issue.
So I guess I'm in between you and the mutualists, right? So the mutualists think that you abandon things as soon as you step off the property. Like it's impossible to have, what do they call it, distant ownership or remote, absentee ownership or something.
Absentee, yeah.
I don't agree with that at all, because I do think that if you do not intend to abandon something, then you don't abandon it, because ownership is the union of the intention to own with possession. That's how ownership happens. That's what homesteading is. That's what distinguishes
you have to mean
it from
to own something. Yeah, you can't accidentally own something, right?
Well, that's why you can sell things, is because you give up your intent to keep it under your ownership and you transfer it to someone else. So it's possible to give up it's possible to lose ownership by losing the ingredient of intent to own. Mm-hmm. But the thing is, property rights has an inherently communicative aspect, because just the very notion of consent implies the ability for people to communicate, because you have to communicate whether you grant permission or deny permission for someone to use your resource, right? Or whether you sell it to them or not. So communication is inherent. Language and communication or have to be part of the understanding of property rights. We have to presuppose that people can communicate, but language is always contextual, and just like contracts can never cover every specificity, there always has to be gap filler rules, or what we call suppletive provisions, or default provisions, or tacit provisions, or implicit understandings that fill in the gaps when language is unclear or we're not sure. So, you have things like good faith, the reasonable man standard, things like that. So, So for example, if I loan you my car, I just hand you the keys. Just because of our previous history and customs and traditions in our community, I didn't say I'm giving you the car forever, but I didn't say I wasn't. I was silent. So what's the reasonable person going to understand? What was my communication that was not expressly stated? We have to make some assumptions about language and people's interactions with each other, and we would say, no, I'm just loaning it to you temporarily, and you have to give it back to me when I ask for it back. If you kiss a girl without her permission, then that's assault and battery, or it's battery. But if she gives you permission, it's not assault and battery. So if you're dating a girl and on your fifth date, you've kissed her every time you walk her to her door, and on the fifth date, you walk her to her door and you give her a kiss, you can assume that she consents because she consented the last 4 times and she didn't say anything different, right? So context matters, and interpretation of unwritten sort of communication matters. And I think that plays into the abandonment issue. So if I have a farm and I explicitly abandon it, I tell everyone in town, I'm leaving town, I don't want this thing anymore, it's unowned. Okay, I've abandoned it by making my intentions expressly clear, right? You with me so far?
Yeah, I am. Yep.
So, but what if I leave town and no one knows where I've gone, and it's 30 years later and it's growing up with weeds and no one even knows if I'm still alive? So at a certain point in time, people are going to assume, and what if someone moves in and they start using it and they're there for another generation? They're going to assume that someone who didn't want to abandon it would have come back and kicked the person out, right? That's why the acquisitive prescription usually says you lose your land if someone squats on it and you don't complain for like years, 15 years, 30 years, depends upon the state or the jurisdiction. And that's different than what the mutualists say. Like, so the mutualists say that you abandon it even if you say you're not abandoning it.
Yeah.
All we're doing with the acquisitive prescription assumption is saying, look, we don't know what the guy wanted to do because he didn't say. So we have to make a reasonable guess. Did he really intend to abandon or not? And so the problem is his fault for not being clear. So when someone is not clear, the people left remaining to decide what to do with the property have no choice but to try to make a reasonable guess at what was really meant. So I do think that you can assume abandonment at a certain point. Especially again, if you're like Ted Turner and you have this big ranch in Montana or whatever, and someone builds a farm on the corner of it because they think they said that there's a mistake about the property line. They actually just think they own it and they build it. And Ted Turner doesn't say anything for 30 years. Then you could say that he didn't police his property and he effectively abandoned it in their favor because he had 30 years to make the decision. It's like the abortion thing. Like if you haven't decided to abort by 4 months, okay, you've had enough time, At a certain point.
I don't like the subjectivity that this introduces. I think I will continue defending the no abandonment thing. So I guess it comes down to like.
I respect that. I respect that.
So yeah, well, like in in 30 years, when the owner returns to the farm and he says, "Hey, that's my farm, get off," and they go to court, and the court says, "Okay, well, show me your your highest claim to the property, farmer," and he shows, I don't know, the original evidence or deed to the property or whatever. Assume no statist deeds, whatever. And then the squatters, or whatever you want to call them, the people that moved in after the fact thinking it was abandoned, it would be on them to show proof of abandonment. Like they would have to show a document or, some kind of recording or evidence that the farmer, the original owner, said, "Okay, I abandoned this property. It's no longer mine." And then they can come in with that proof of abandonment. Otherwise they don't have the highest claim to the property, right?
Well, maybe the customary rules in that community would be, if you can't find the guy and track him down, put a notice in the newspaper and give him a year to respond. And if the guy finally doesn't, maybe you have to have some duty to try to find the guy. But if he's just if he's not cooperating in the system, and by the way, another way that could solve this, you could have agreements which basically handle these things, like, if I buy land and I have to get a mortgage on it, maybe the bank,
like title insurance.
Yeah, it'd be like a title insurance type of thing, which basically it says, okay. And again, when I say communication is essential, let me give another example. Suppose you're in a neighborhood and it's customary for people to walk up to their neighbors' doors and knock on them to ask them for a favor, or a question, like, "Hey, do you know when the garbage comes tomorrow?" Or could you loan me a cup of sugar or something like that? Now, when I walk up to my neighbor's house, technically I'm using their property. So is it trespass or is it consented to? Now, I would say it's not trespass because there's an implicit understanding that the owner is granting permission, because that's commonly done in the neighborhood. So unless I derogate from that by putting up a postage sign and stating the opposite to the normal customary understanding, then I have basically, by silence, agreed to consent to innocuous uses like that, right? Yeah. Now, you could say something like that is true of the abandonment case. Like if it's understood in a given community, even if you don't personally like this rule, but if this is what the practice that's going on, if everyone says, "Look, if you don't show up here for 10 years, we're going to declare this to be unowned. Someone's going to move in and you're going to lose it." And if you know that's the rule, then it's kind of on you to rebut that by, every 9 years showing up and visiting or something like that.
As long as he consented to that rule in the first place. But also he could withdraw his consent to that rule. Like, it's his property. To encroach upon it in that way would be to reduce his property
you're right.
rights.
You're right. My solution doesn't work.
Sorry.
By the way, you notice I didn't put that in the principles because that's too specific in this. So I didn't put abandonment in there. So that's still up to interpretation. But your argument is arguable. Well, let me ask you this: Do you think that if some Native Americans could show that part of Manhattan was stolen from them, that they should get it back even now?
I could imagine a very specific scenario in which they could show a higher claim to the property, like a specific Native American.
Me too, by the way.
Yeah, and just to clarify for everybody watching, because I get this a lot, like it would need to be like a specific person with a specific claim to a specific section of property. Correct. Where they could show non-communal sort of ownership of that, because Native Americans had this they didn't, a lot of Native American tribes didn't even have a concept of private ownership of property. They were nomadic and they just kind of roamed around. So that would be insufficient. So it would have to be a very specific situation, but I think you could conceive of one.
Me too.
Yeah. Okay.
But the reason is because they didn't abandon it. It was basically stolen, right? They were not allowed to make a claim for it all these generations. Maybe a better example would be like the descendants of a slave who was on a plantation. And maybe the heirs of the white master still own it. Maybe the black slave's great grandchildren should be able to get that back. I'm not opposed to that kind of stuff at all, as long as you can show a particular enough claim, the right evidence. But the problem is old claims, evidence tends to be lost. Witnesses are all dead.
Yep.
So that's why that's sort of the reasoning behind the statute of limitations, that if you don't assert your rights when they're fresh enough to be able to do justice, if you wait too long, then you've lost your right to.
It can become impossible.
System.
Yeah.
it becomes impossible and it becomes unfair to the other side because they some of the witnesses they might have needed are now dead and all this kind of stuff. So there's a reason that claims that become too stale or barred. You know, in the common law, this is called Latches, Laches, which is sort of the time equivalent of estoppel, which is another type of equitable defense you can use to prevent someone from making a claim that's unfair for them to make. Again, if you wait too long to assert your rights, then it's just you've lost your right to do it. And that's the logic behind acquisitive prescription, is that if someone's squatting on your property, you have 30 years to kick them out. But if you don't do it, eventually it's too late for you to assert your rights. You've given up your rights. I understand you don't quite agree with it, and I don't. It's not something you can prove with deductive reasoning for sure.
You said something really important early on that I want to highlight. You said that it's not these property systems, these rules are not some kind of a priori axiomatic thing that we can extract from the fabric of reality. Property rights are agreements between people. When we talk about having rights to property, we're talking about what rights are, which are reciprocal agreements between people. And so
correct.
You can reciprocate whatever retarded property rights you want amongst people that consent in an area, let's say. But I think what we're arguing for and what we're in search of is the most consistent, the most universalizable, the least rivalrous set of property rules that we can imagine, because that's the whole point.
And they have to be workable and practical, because property is a practical solution to a real problem. And the problem is the problem of conflict. So for the group of people, which is most people, who would prefer to live in a society where we can peacefully trade with each other and deal with each other rather than have physically fighting. So we kind of agree that we need a system of property rights, right? So then the question is, what are they? And that's what I laid out in my plank, is like, those are the rules. And those are the rules that evolved on the private common law anyway, original appropriation and homesteading and rectification for a tort. I mean, that was the core of the Western private law anyway, and the Roman law as well. So like one of the rules has to be self-ownership, because I mean, it doesn't even make sense to say you own real estate or something if you don't own yourself. So that's the core thing. And then you have to be able to use things in the first place for people to survive. So we have to have the ability to go out into the woods and get things that are unowned. Otherwise we would die. Mm-hmm. So whatever the rules are, they have to permit original appropriation, right? So, and if you believe in property rights at all, part of that is what Hoppe emphasizes. It's called the prior-later distinction, which means it matters who has it first. Because if it doesn't matter who has it first, then there's no property rights, because just because I own something now, someone else can come and take it from me, right? Yes. The very notion of property rights implies that the current user owner has a better claim than someone who comes later. So yes. If you combine that with the idea that we have to be able to use things that are unowned in the first place, combine that with the need for property, and combine that with the prior-later distinction, that means that the first person to use a resource is the owner. So that's original appropriation. And then owning it means you can abandon it. And if you can abandon it, you can give it to someone. That's what this contract comes from: the right to use it and the right to abandon it. And then the security of property rights, meaning you can't trespass against someone's property without their permission, means that if someone does, they have to owe you compensation. So that's the third way. So it all sort of flows from the basic practical need for conflict avoidance mechanisms.
Okay, so we have a person over on Odyssey that has just been commenting up a storm. I can't catch up with all your comments. It sounds like you have some fundamental disagreements with myself and Kinsella on the conception of property. You're welcome to hit us up on Twitter. My Twitter is @notgovernor. Stephan, your Twitter is... What's your Twitter?
NS Kinsella.
NS Kinsella. Sorry, I didn't have that ready. Yeah, so send us a tweet, and maybe we can have a back and forth. And if we find that there's some actual meaty disagreements, then we can definitely have the discussion on stream. I have a couple super chats here, but let me make this last call for questions or challenges in the comments. Write question in all caps and give me your question, and we'll get to it. Zeku, thank you for the $5 super chat. He says, "Woo freedom." And Phobes donated $5. Thank you for that. He says, "No definition of aggression? Makes sense. The LP was run by woke commie redacteds until the Mises crew took over." What are your thoughts? Do you have any thoughts on the Mises guys?
Me? On the Mises caucus?
Yeah.
Well, I'm a member. I thought it was great. I think, look, I've never been a political activist. I think politics is futile. I still do. But I did join the party about 4 years ago because I just thought I got tired of them not running libertarians and not having a clear libertarian message. I figure if they're going to run, because all my friends think the Libertarian Party is what libertarianism is, right? So I just want them to have a consistent libertarian message and good libertarian, articulate libertarian candidate. That's all. I don't think we're going to win the presidency or anything, but I do want them, and I think it can be a good way to spread our ideas. I mean, a lot of people learn about it from that. So that was my goal, and I do think the Mises Caucus is solid on that. They're Austrian influence. They're principled. They're anti-war. They're anti-COVID lockdown. So I think it's been a great development.
I agree completely on all counts. I think the LP is, as a political entity, is a big waste of time. It might even be a honeypot that wastes a lot of good, meaning, well-intentioned activists' time. But man, has the messaging been garbage for the last 10 years, and holy shit, has the past few months, now that the Mises has taken over, especially on Twitter, oh, they're on fire. And finally, if nothing else, they're saying the right things to the people that need to hear it. So I'm excited about that. Okay, so we did get a few questions here. Question: when somebody watches the pirated copy and tells their friends that might pay for it, that is free marketing, right?
Yeah, that's one argument a lot of people have made, is that piracy actually often helps the producer. But that's sort of a utilitarian justification, and it's contingent. I mean, it's not. I don't think it's not always the case. I do think piracy for music and for movies probably does reduce their sales to some degree. Just like musicians don't make as much money now as they used to from CD sales. Back in the golden era of CDs, they were making so much money because there was only one business model, and it was not easy to duplicate. But now we have streaming and MP3 files that's faded away. That's because of technology and the internet. So business models change over time as technology changes.
All right, next question. If we insert practicality into a non-arbitrary foundation, wouldn't that just be inserting some kind of subjective gobbledygook that promotes conflict rather than reducing it? I guess we're going back to the property. If we insert practicality into non-arbitrary foundation, wouldn't that just be inserting some kind of subjective gobbledygook that promotes conflict rather than reducing it?
I think you can actually make a pretty good. I follow Hans Hermann Hoppe's argumentation ethics. I think that's actually the philosophical way to justify and defend rights. And when I talk about practicality, I'm more describing the system that has emerged and explaining why it emerges. But I do think that you can make actual principled arguments for like the rules that we put in the platform. I think you could defend each one of those, as I just did. But just admitting that property solves a practical problem, it just means we have human bodies, and we live in a world where there's, we need things to survive. We need scarce resources to act. I don't think that's devolving into consequentialism or utilitarianism or unprincipled thinking.
All right, last question. If someone without an apparent heir dies, would the property then be up for homestead? I mean, I would say yes. And
yes, although it's those cases are very rare because the law usually has different layers of presumptions of who would inherit. But under current law, do you know what happens if that happens?
The government taxes a certain percentage of it, right? If there is no apparent heir, yeah. If
there's no heir, then the government gets it. It's called escheat, ESCHEAT. So the government is the backup. In the government's conception, there can be no unowned land. It's impossible to have unowned land in the government's conception.
That's a shitty deal.
Yeah. So I would say yes. It's up for grabs as soon as it has no owner, and it has no owner if you die with no heir.
I'll see myself out for that dad joke.
Oh, what was it? Sorry, what was it?
I said that's a sheety deal. You said it's a sheet, and all right. Thank you for
wearing my dad joke shirt right now, which says,
that's bad.
My shirt says, "I like telling dad jokes. Sometimes he laughs."
All right. Mr. Kinsella, as always, it's a pleasure to chat with you. Thanks for coming on today. Is there anything else you'd like to say, or can you direct people to your website?
Just StephanKinsella.com.
There you go. All right. Thanks everybody for watching. Until next time.